Hey boss, so today we have an interesting one. Let's talk Palworld, the new open world action adventure crafting and survival game that people have given the moniker Pokemon with guns. Since its launch on Steam and Xbox on January 19th, the game has proved to be extremely popular, selling over 12 million copies since its release. Now, sales numbers like those make Palworld a huge commercial success. The type of commercial success that the game industry as a whole has to pay attention to. And not only is the game selling really well, people seem to really be enjoying it, with over 95% positive ratings on Steam alone. But as many of you may know, Pocket Pair, the creators of Palworld, are garnering a lot of attention for the creature designs. Specifically, many fans of the Pokemon franchise are pointing out similarities between some Pokemon and a lot of the pals in Palworld. I have also seen various people put forth excellent arguments defending Palworld from all the plagiarism accusations. And things got even more interesting when the Pokemon Company themselves weighed in briefly on the topic, stating, "We intend to investigate and take appropriate measures to address any acts that infringe on the intellectual property rights related to Pokemon." Now, regardless of which side you personally fall on in this debate, I'm not here to tell you if I agree with you or not. There are plenty of other videos on this platform that do that. Instead, I'm going to break down the legal perspective that 99% of people seem to be missing, and explain to you how the very fact that we're having this conversation could be enough to help the Pokemon Company win this case. But before we get started, I'd like to point out that I am not a lawyer. What's more, intellectual property law is a very complicated and rather nuanced subject. So this video is not legal advice. I have had to deal with the topic of intellectual property law in quite a few of the deals that I've closed in my career on Wall Street, so this should be a very fun video for me to make. If you like the video, please like, subscribe, and comment. Without further ado, let's get to work. So, Palworld. It's a game that seemingly came out of nowhere and has owned internet discourse since its release. Although both the Pokemon Company and Pocket Pair are Japanese companies, I'm going to be speaking about the intellectual property laws in America, because there is a good chance that if Pokemon does sue, they will be suing using American courts as well. Yep, let's go with that. It has nothing to do with the fact that the closest I've ever been to the Japanese judicial system is Ace Attorney, the anime. So in general, there are 4 facets of intellectual property laws that companies have to worry about. Those are trade secrets, patents, copyrights, and trademarks. In the case of Pokemon vs. Palworld, we are really only looking at the last 2, copyrights and trademarks. That is because patents mostly deal with innovative inventions, such as machines, manufactured products, composition of matter, like a new metal alloy or something, processes, or an improvement on any one of those things that I just named. As you can tell, Pokemon designs don't fall into any one of those categories. Similarly, Pokemon designs are not trade secrets because they are readily available for the public to see. Make sense? Good. Now let's talk about the other 2 types of IPs, starting with copyrights. Most people who believe that Palworld is copying Pokemon are referring to copyright infringement. Ironic, because I believe the copyright infringement is probably the Pokemon Company's weakest suit. You see, copyright law is intended to protect all original works of authorship. In this case, original does not mean new, but that the expression was original to this particular person, i.e., not copied from another source. In my estimation, unless Palworld stole actual game assets from any of the Pokemon games, then the copyright argument is very unlikely to work. When contemplating copyright infringement cases, courts often use the extrinsic and intrinsic test. And if the work that is being dissected, in this case Palworld and its pals, passes the extrinsic test, then the judge is likely to dismiss the case altogether. The extrinsic test is just an objective comparison of specific expressive elements. Unfortunately for Pokemon, I believe that Palworld pretty easily clears this bar in regards to the game as well as the pals themselves. Pocket Pair could likely argue, and rightfully so, that any similarities between pals and Pokemon are due to the similar premise of making a game in which you can collect little monsters, many of which resemble real-life animals. That premise is an idea that cannot be copyrighted. Now, if the court agrees that most, if not all similarities stem from the shared premises of the game, then they would be able to dismiss the case outright and grant summary judgment in favor of Pocket Pair and Palworld. Now, before the Sue Pocket Pair into Oblivion Wing crowd starts getting upset with me, I am not denying that there are various rip-off looking pals in the game. Vixie, Cremis, Dumud, Lookmoon, Fanglo, Cruisebolt, Glarus, and Berserk are all rip-offs at worst. So, I get it. All I am saying is that unless Pocket Pair stole or one-for-one copied assets, it is unlikely that Pokemon would win a lawsuit based on the similarity of the pals to their Pokemon. Especially knowing that if all else fails, Pocket Pair could use the parody or satire defense and argue that they are protected under fair use. But alright, now that I have explained how I believe a copyright suit would likely play out, let's get to the really interesting part. How could Pokemon win their lawsuit against Pocket Pair? And the answer to that is that Pokemon could sue Pocket Pair for trademark infringement. You see, in trademark law, Pokemon does have what I believe to be a much stronger case against Pocket Pair. Ironically enough, they would use the words of both Palworld enjoyers and detractors alike. And that fan moniker, Pokemon with Guns, could be the final nail that Nintendo needs to bury Palworld for good. Sorry guys, but I'm getting a little bit ahead of myself here. Let's start by talking about what is trademark law. A trademark is any distinctive word, phrase, symbol, or design adopted for the purpose of identifying the origin of goods being offered for sale. For example, every time you see the trademark Pokemon on a gaming product, you probably assume that the product was made by Game Freak and the Pokémon Company. Similarly, when you see Pikachu in another game that doesn't have the Pokemon name, think Smash Bros., you as the consumer can still assume that the Pokémon Company knew and approved of this edition and they had something to do with the game. So in these cases, you can tell that the Pokemon name as well as Pikachu are both trademarked by Pokemon and are both used to identify Pokemon as a company and provider of goods. This is because trademarks are meant to help the consumer to identify goods or services that they enjoyed in the past and reject those that they didn't like. Trademark laws serve as motivation for businesses to maintain and improve their products and services so they can benefit from a widely popular and trusted trademark. Therefore, trademark infringement occurs when a competitor of the trademark owner uses a mark so similar that the purchasers of the product could be misled as to the origin of the product or service. The first question then becomes, are Palworld's pals similar enough to Pokemon to legitimately confuse a buyer as to who makes the game? And if so, Palworld could be said to be getting a free ride on the reputation built by the Pokemon Company, and that would indeed constitute trademark infringement. Furthermore, according to the FTDA, Federal Trademark Dilution Act, a famous trademark like Pokemon would have an even lower burden of proof than the typical plaintiff in this type of case. In most trademark infringement cases, the plaintiff, in this case the Pokemon Company, would have to prove that there is a high likelihood of confusion for consumers as to the true origin of Palworld. They could also win the case by proving that consumers are likely to be confused about affiliation, sponsorship, or endorsement. Proving either claim, though, is a question of fact, and so Pokemon would need evidence to support what they're saying. In such cases, factors such as similarity of design, similarity of product, proof of confusion among actual buyers, and marketing surveys amongst actual potential purchasers would be used to decide the case. Pokémon would likely have the high ground when it comes to similarity of the product. This is because Pokemon's trademarks are mostly associated with video games, and Palworld is exactly that, a video game. So it is very easy to imagine someone believing that the Pokémon Company, a company that has been making monster hunting games for over 25 years, has now made another monster hunting game. This is especially true because although the PALs and Palworlds are not illegal, they are very derivative. This becomes even clearer when you include the added context that many are calling the game Pokémon with guns. This moniker even helps take care of point number 3, proof of actual confusion amongst buyers. Here, all the Pokémon Company has to do is show how often the game is referred to as Pokémon with guns. A quick Google search for the term returns over 7.7 million results across the internet. Pokémon could easily argue that tens of millions of potential buyers could be using or being misled by the moniker. They could also argue that such a moniker could severely hurt their ability to sell games. After all, a lot of parents could stop buying Pokémon games for their children because of the false belief that Pokémon has now started including guns in their games. The Pokémon Company could also pretty easily scrub Twitch, YouTube, and every other platform that covers gaming for all the instances in which a famous streamer or popular post refer to the pals themselves as Pokemon. I believe Nintendo and the Pokemon Company would have no trouble at all finding hundreds, if not thousands, of such instances. Another piece of evidence that they could use in order to paint the picture of millions of confused consumers is the fact that a lot of people have been referring to differently colored pals as shiny, a term that was historically used to describe Pokemon with different color palettes. We've already seen people create Pokemon mods of Palworld. The link between the two games obviously exists in the mind of the consumer. All the Pokemon Company has to do is focus on crafting a good lawsuit from that link. With all this being said, I honestly believe that Pocket Pair would have an uphill battle on their hands. This is such a good demonstration of the power that consumers have and why it is so important for a company to control the narrative around their own product. Although Pocket Pair may have done everything right within the game to avoid a lawsuit, their inability to control all the Pokemon comparisons could end with their most popular game ever being taken off the market, at least in America. This fan-made moniker that has caught on with the internet may have handed Nintendo and the Pokemon Company what could be one of the most important legal wins in gaming history. And you better believe that if I have thought about this angle, Pokemon, one of the most litigious companies in the world, has definitely thought of it. I wouldn't be surprised if they are collecting their proof, aligning their ducks, and getting that lawsuit ready as we speak.